Most all of us are losing our access to court. It's become normalized, and it generally goes unnoticed until we're kicked out of court when we need help. I'm attorney Steve Matcha. I represent employees, and in this video we'll talk about forced arbitration. It all starts with an agreement to arbitrate, putting us between a rock and a hard place. It's take it or leave it, and for employees that means take arbitration or leave the job. In his statement to Congress, retired Major General Jeffrey Phillips explains it like this: "It is hard to accept that consent is voluntary when a person agrees to binding arbitration upon employment. Most people take jobs because they need to pay the rent and put food on the table. It is perhaps unsurprising that they may overlook the future risk of arbitration for the present need of income. Binding arbitration holds hostage the ability to provide food and housing for individuals and their families." To make this more concrete, let's quickly take a look at two examples, and while we do that, consider the various situations in which there's paperwork while you, your family, or friends are just going about your business. In Colorado Healthcare LLC versus Fisher, Judith Fisher admitted her mother, Charlotte, into a nursing home, and the paperwork included an arbitration clause. A nursing home attendant threw 90-year-old Charlotte against the wall, fracturing her hip. Charlotte died, and the county coroner classified her death as a homicide. The family went to court, and because of the arbitration clause, the case was thrown out, and they were forced to arbitrate. In Dagnan versus St. John's Military School, Mr. Dagnan enrolled his son, and the paperwork included an arbitration clause binding both Mr. Dagnan and his son. Mr. Dagnan eventually went to court, explaining his son was sexually assaulted at the boarding school when he was 12, and the school was aware of similar incidents involving the same assailant. The case was thrown out and forced into arbitration. Blocking our access to court and forcing us into arbitration is problematic for a variety of reasons. While it may be suitable for business-to-business disputes, for everyday people it's clearly inferior. Again, it starts with a forced agreement. For groups of people mistreated by company practices, the companies divide and conquer. So what that means is the arbitration clauses block them from joining together to fix the problem. For example, let's say there's a glitch in a company's billing or checkout system, charging customers $10 for goods or services they didn't receive or even want. Now in court, that could be resolved in one case. The attorneys hash it out, they collect the money, and distribute it to the customers. With individual arbitration, most people wouldn't make a stink about $10. And from a company's perspective, that's probably the point. So they don't have to correct the situation, or not for many people, and they can even continue profiting from it. What about when decisions are wrong? It happens sometimes. In court, we can appeal it to a higher court to evaluate the decision and decide whether it was correctly ruled. In arbitration, unless the company allows it, and in all but the worst circumstances, the arbitrator's decision is final, even if the arbitrator is wrong on the law or misapplied it. How about the truth?
You want answers!
I want the truth!
Let's see if we can handle it. In court, we're given the option of an unbiased jury from the community to weigh the evidence and decide what's true, what actually happened. With arbitration, bias is practically hardwired into the system. Arbitration is a business, and its customers are the companies that are funding it and repeatedly using and forcing us to use it. If that sounds unfair to you, you're in the good company of several judges. At the Pound Civil Justice Institute's 22nd Annual Forum, 144 appellate judges discussed the topic, forced arbitration and the fate of the Seventh Amendment, the core of America's legal system at stake. Their comments included, if people think they still have the right to sue after signing a contract, that means they are clinging to something very deep, their right to bring an action that they don't believe they could possibly have signed away. Also, the courts are supposed to be the place where we get it right, where we see that all of the cards get played. I don't think that's happening anymore. I don't buy it for a second that arbitration is there to protect any consumer. It is not. It is there to protect the business model. Allowing companies to herd us out of court and force us into arbitration makes the foxes guardians of the chickens. Right now, Congress is considering the Fair or Forced Arbitration Injustice Repeal Act. And if you believe that we should all have unobstructed access to court, please spread awareness. And an easy way to do that is by reposting this video. Please also consider this. Under our constitutional system, Courts stand against any winds that blow as havens of refuge for those who might otherwise suffer because they are helpless, weak, outnumbered, or because they are non-conforming victims of prejudice and public excitement, and that's worth protecting.